Thank you. Whenever the appellant is ready.
Thank you. Good morning, Justices of the Court. My name is Quinn MacDonald, and I'm here today alongside my co-counsel, Mr. Matthew Jewell, for the appellant, Her Majesty the Queen. Before I proceed, I would like to begin by acknowledging that the land on which myself and my colleague are located on is the traditional unceded land of the Algonquin people. The Algonquin people have lived on this land since time immemorial, and I am grateful to have the opportunity to be present in this territory. The issue before the court today is whether a member of an Aboriginal collective located outside of Canada can claim a constitutional protections of Section 35. The appellant has two submissions to make to the court today. First, the appellant will submit that a purposive interpretation of Section 35's Aboriginal rights cannot be extended to Aboriginal groups located outside of Canada. Secondly, my colleague will submit the public policy implications of upholding this appeal. Before I proceed, would Your Honors like a brief summary of the facts?
No, please proceed.
Our submissions here today is that the courts below have interpreted Section 35 and the rights entailed in error by interpreting the provisions of Canada to apply it to the Aboriginal groups not located in Canada, or in the case of the Lakes tribe, located wholly in another country. In both Vanderpeet and Sparrow's jurisprudence, the Supreme Court affirmed that Section 35 must be interpreted purposively. Our position is that Section 35 purposively interpreted with regard for the linguistic, philosophical, and historical context of Section 35 leads us to the conclusion that Section 35 does not include within its scope Indigenous groups that are wholly located outside of Canada. Beginning with the textual analysis of Section 35, it has been well established within Canadian jurisprudence that constitutional interpretation must begin with the text itself in question, and that the guiding principles of a purposive interpretation do not undermine the primacy of the written text of the Constitution. In beginning this analysis, as established within Sullivan's statutory interpretation, there is a presumption that every feature of a legislative text has been deliberately chosen and has a particular role to play in the legislative design. Thus, in examining the text of Section 35, specific meaning and thought has been afforded by the legislative drafters to the two words "of Canada." As taken from Shroud's judicial dictionary, the word "of" in context of a place imports the meaning dwelling at the place named. Accordingly, considerable weight must be afforded to the presumption against tautology, which would indicate that faced with the option to include a geographical qualifier in the words "of Canada" within Section 35 as opposed to merely Aboriginal peoples, the drafters had deliberately chosen to include it and not for stylistic purposes. In the context where the word "of" in relation to a place, it is important to note that this is synonymous with the word "in." It follows that the inclusion of the words "in Canada" cannot be seen as superfluous.
Counsel, if we're under this presumption that specific meaning and thought is given to the language in the Constitution, so there is specific meaning and thought given to the choice of the word Aboriginal, which means original. So if we take the understanding that this refers to the people who were here originally and what is now Canada, would that definition not also include Mr. Desautel, even though currently he is outside of Canada?
Your Honor, it's important that we go back to the intended protections within Section 35. As noted within the case of Big M, the purpose should be understood in relation to the interest in which it was meant to protect. Section 35 protects Aboriginal peoples as full participants with non-Aboriginal groups in a shared Canadian society, which I would add emphasis to the word Canadians. Furthermore, in both the Queen Anne Blais and Frank and the Queen, the Supreme Court of Canada has considered similar language as a means of interpretation. In the case of Section 35, numerous geographical qualifiers outside of Section 35 exist within the Constitution. For example, the use of the terminology citizens of Canada within Sections 3, 6, and 23 are also included within the Constitution, thus interpreting the phrase Aboriginal peoples of Canada in a more expansive fashion would be contrary to the meaning intended by the drafters.
But Counsel, would you not agree that, and I get the fact about the geographical qualifier constitution, right? But I think Aboriginal peoples, there's another qualifier we should be taking into account, and that's the time qualifier of first contact, right? There's no argument that when Mr. Desautel's previous, the tribes before him that he seceded from, those were people who were in Canada at time of first contact, right? So why shouldn't Of Canada expand to include those groups when you consider the time and the historical context, as you mentioned earlier, instead of looking at a geographical qualifier that Constitution just arbitrarily draws a line on the 49th parallel?
Your Honor, as the court in Blay has noted, the court is not free to invent new obligations foreign to the original purpose of the provision at issue, to which we can take from note for which we can review the parliamentary debates prior to the enactment of the Constitution, in which it is clear that the legislative intent within the minutes for the scope of Section 35 was implicitly limited to Aboriginal peoples of Canada in order to properly protect the Aboriginal groups within Canada.
Counsel, but is it not true that the committee members didn't turn their mind to this issue? Not that they were, can we really say that they purposefully limited the scope if they simply did not turn their mind to this issue that Mr. Desautel is bringing up today?
The respondents would like to submit that merely because the issue is not discussed does not mean that it was not implicitly within the Constitution's framework. And it was rather that the minutes surrounding the drafting of the Constitution, and in particular Section 35, would indicate that the provisions were faced with a geographical and spatial qualifier. As indicated at paragraphs 116 and 117 of the lower court's decision, repeated references to the claim Native Canadians, or as Nellie Carlson interpreted the scope of Aboriginal peoples of Canada, an Indian who has been born and raised within this country, which accordingly must be given considerable weight when interpreting Section 35 in a purposive manner, as it gives considerable weight as to what the intentions of the drafters were, which, as I may reaffirm, Section 35's purpose should be understood in relation to the interest it was meant to protect. Accordingly, as affirmed within Mitchell, Section 35 only protects Aboriginal peoples as full participants with non-Aboriginal peoples in a shared Canadian society.
And Counsel, you keep driving at this point. I want to understand it a little bit further. What is the difference between protecting those who are part of this shared Canadian society, as you assert, versus those like Mr. Desautel, which you're asserting aren't participants?
Justice, we believe that within the scope of Section 35, the protections of reconciliation must be focused on those located within Canada, rather as denoted within the current situation within the Maritimes, where there's a lobster shortage. What can we do when we afford an Aboriginal right to hunt to foreigners within the Maritimes when the Aboriginal groups within Canada already have a shortage of lobsters and would therefore be implicitly affected by affording rights to foreign groups, which would ultimately affect the Aboriginal groups of Canada first? Furthermore, the judiciary has consistently interpreted through its wealth of jurisprudence surrounding Section 35 the importation of implying of a residency or citizenship requirement within the Aboriginal right in Section 35. As noted
Counsel,
within—
Can I interrupt you for a minute, because you only have about a minute left? Are there any arguments you wish for us to consider that were not considered by the lower court?
Justice, as I see my time is elapsing, may I take a moment to briefly answer your question and conclude?
Sure.
Thank you. We believe ultimately that Section 35's purpose must be grounded within the interpretation of how the constitutional drafters and the legislator intended for its purposes and protections to ultimately be afforded to Aboriginal peoples of Canada, to which we would ultimately argue and submit that it is only those located within Canada.
Isn't that the same arguments that were made in the lower court?
Yes, Your Honor, but we would like
So
to.
do you have any arguments that were not considered by the lower court?
Your Honor, we believe that the lower court's interpretations of our arguments was ultimately an error, which is why we must be afforded consideration and proper interpretation at this level of the judiciary.
Thank you, counsel. That is time. Thank you.
Thank you.
May I proceed?
Please go ahead.
Thank you and good morning, Justices Eichelboom, Goldlist, and Wu. My name is Matthew Jewell, and I will be concluding the submissions as begun by my co-counsel, Mr. Quinn MacDonald, for the appellant, Her Majesty the Queen. My submissions today will pertain to the practical and public policy concerns if this appeal is not granted. The framers' intent of Section 35 was and is to protect the rights of Indigenous peoples that are members of and participants of Canadian society. There was no intention to bestow rights upon those who have no connection to it. My co-counsel has submitted that a purposive analysis of Mr. Desautel's claims to Section 35 rights requires this court ultimately deny his claim. I must reiterate here why this is not only the correct legal interpretation, but also necessary in light of practical and modern circumstances. As the trial judge found, in fact, the Lakes tribe, which Mr. Desautel belongs to, is wholly located in America and has not so much as hunted upon Canadian land since 1930, nor were they forcibly removed. His people decided to leave Canada over 50 years prior to the creation of Section 35, and not even return until 40 years after in order to extend Canadian rights to foreigners. I would like to also point out here that although the trial judge believed that, or found in fact, that they did not feel that they were welcomed back to Canada because of various legal schemes afforded in regards to hunting, they actually may have came across the border and participated in what they believed were to be their hunting practices on Canadian grounds, as until 2001, there has been very little or any border patrolling along these areas. There is virtually no policing in these areas as well, because it is in areas of very few population. Now, setting aside that the factor of the law was written, it clearly only intended for those located within Canada to claim. It simply does not make legal or practical sense to allow those wholly located outside of Canada to enter and claim rights designed and evolved in law to suit Canadian persons and inhabitants only.
But counsel, one of the things I'm going to go back to your co-counsel's submissions on purpose for just a quick second. I thought the purpose of 35.1 was supposed to be for reconciliation. Are you saying that reconciliation is only for those who have chosen to remain Canadian but are Indigenous? What rights do we afford to those who were Indigenous, were in Canada, but have happened to, vacate to the US or be removed to the US, or what we call the US border now?
With respect, Justice, our submission here today to you is that if Indigenous groups outside of Canada were to be afforded the same rights as those within Canada, there would ultimately become a hierarchy of rights and a hierarchy of rights claimants. As Justice Cote mentioned at paragraph 121, if Indigenous peoples outside of Canada were to be entitled to receive any Canadian Indigenous rights, they must be entitled to all of them, for anything other than this would not uphold the honor of the Crown. to divide Aboriginal groups into those that receive full access of Section 31 and those that merely receive partial access, goes against the process of fair dealing and reconciliation as set out by Haida Nation and British Columbia. As the court found in Vanderpeet at paragraphs 18 and 19, the Charter is understood to contain rights that are in the Enlightenment view, general and universal. But Section 35 is not contained within the Charter. It is entirely separate, and they must be viewed differently as they can only be held by Indigenous members of Canadian society. A finding in favor of Mr. Desautel would allow tribes wholly located in America for over a century to claim the exact same rights as Indigenous groups who have remained and live in Canada. This would not only be unfair to Canadian Indigenous peoples, but would also serve to harm the relationship between the Crown and the Indigenous peoples whom it owes a fiduciary duty to.
Counsel, why would it harm the relationship with Canadian Aboriginals?
With respect, Justice, I would like to bring us back to my co-counsel, Quinn McDonald's response to your earlier question in regards to this, that if we afford the exact same rights to Indigenous peoples not within Canada, not living in Canada, and not Canadian residents or citizens, they may come and use up the resources that are afforded to the Indigenous peoples within Canada and participating in Canadian society.
But are there not other sort of regulatory schemes that govern the distribution of hunting licenses and fishing, stuff like that, for Aboriginal peoples? Aren't there already, what I'm saying is, aren't there already things in place to prevent problems like that?
With respect, Justice, that is why we are here today. Mr. Desautel, instead of using a common law right to hunt that was not uplifted to the status of constitutional status in Section 35, he would like to get around the rules in which were placed upon him for hunting when he came across the border. A finding in favor of Mr. Desautel today would ultimately create a novel fiduciary duty towards Indigenous peoples that aren't even members of the Canadian state. By its nature, this cannot be possible. The Crown's fiduciary duty simply cannot extend to a binding to those not even within Canada. What we are here to grapple with today is to ultimately further reconciliation with Indigenous peoples of Canada. With that being said, we cannot simply erase the common law by annihilating the borders of two nation states and erasing Canadian sovereignty. We must reconcile the Aboriginal perspective with the common law perspective and come to a solution that respects them both. And that is the position we submit to you today. The litigation here today need not be a zero-sum game. Mr. Desautel may very well retain a common law right to hunt, albeit he desired not to argue this in light of the fact that it would exempt him from the regulatory charges in which he was charged under. This does not mean that they are no longer available to him. In conclusion, Justices, on behalf of Her Majesty the Queen, we have made two main submissions for the court to you today. First, that a purposive interpretation of Section 35 simply cannot extend to Aboriginal peoples located outside of Canada. And second, that the contextual factors surrounding the respondents' assertions today would be impractical and cause a plethora of legal issues. Barring any further questions, the appellant requests that you grant the appeal, respecting the natural limits of the Constitution and ensuring the rights of Canadian Indigenous peoples are respected.
Counsel, could you take a moment to address very quickly some of the comments raised in the lower court in dissent about the continuity test in Vanderpeet as it applies to Mr. Desautel?
Yes, Justice. In regards to that point, we would submit that as I had earlier mentioned to you, was that it was easily possible for the Lakes tribe, Mr. Desautel's people, to come across the border and do as he has just done. It was only until 2001 that there really became a new issue in which people became to be monitored crossing the border. During that time, roughly 70 years, they could have been coming across the border and participating in this hunting, but they chose not to. So this here breaks that level of continuity and can no longer pass the Vanderpeet test. Thank you.
Thank you. Respondents, whenever you're ready.
Good morning, honorable justices of the court. My name is Rebecca Tiley. Here's my colleague Avery McKinley, and we are here on behalf of the respondent, Mr. Richard Lee Desautel. At issue before the court here today is that an interpretation of Section 35 that excludes the Lakes tribes would run contrary to the fundamental nature of Section 35 and defeat the promise that Section 35 represents to protect Aboriginal rights. Therefore, it is the respondent's position that the Supreme Court of Canada was correct in determining that Sections 11(1) and 47A of the Wildlife Act are of no force or effect with respect to the application of Section 35 of the 1982 Constitution Act to Mr. Desautel. We respectfully request the Supreme Court of Lions Cup to uphold the lower court's decision, exempt Mr. Desautel from the Wildlife Act provisions under which he was charged, and dismiss the appeal. To this end, the respondent today has two submissions to make. I will submit the first, and my colleague will submit the second. Our first submission is that under the scope of Section 35, the phrase Aboriginal peoples of Canada does include Mr. Desautel. The second submission is that Mr. Desautel does have the right to hunt, as the requirement for continuity in the test for Aboriginal rights has been met. To begin with the first submission, before turning to why a residency or citizenship requirement is fundamentally contrary to the purposes of Section 35, I would like to first address the linguistic and historical context that my friends raised. To turn to that linguistic context first, our friends submitted that every feature of the legislative text has been deliberately chosen and has a role to play. And in line with that reasoning, we submit that the court should read the phrase as a whole, Aboriginal peoples of Canada. In interpreting Section 35, because it is specific to Aboriginal peoples, the court cannot ignore the specificity that Section 35 grants, which is a special constitutional protection that arises from one fact that separates Aboriginal peoples from the rest of Canadian minorities. And that is the fact that they occupied Canada prior to the assertion of European arrival. Our friends also raised the 1978 Supreme Court of Canada case of the Frank and the Queen, and also the 2003 Supreme Court of Canada case of the Crown and Blaze, and referred to how the court has interpreted of Canada in those cases. Both of those cases were about the National Resource Transfer Agreements, and those are constitutional agreements, not the Constitution. As the court has held in the 2016 Supreme Court of Canada case of Daniels and Canada, India Affairs and Northern Development, paragraph 44, the National Research Transfer Agreements, as constitutional agreements, require a different interpretive exercise than the Constitution itself. And so we submit that those cases hold no weight here, and that Section 35 does not need to be interpreted in line with the NRTAs. To turn to the historic context that our friends raised, and they brought forth the minutes that were cited by the dissent. We agree with our friends that drafting history can be relevant to constitutional interpretation, but what we take issue with is that in the minutes, they never addressed that question directly of whether or not Aboriginal peoples located outside of Canada should be included under the scope of Section 35. However, this is a novel issue before the court, And it may be true that in 1980, when the minutes were drafted, or in 1982, when the Constitution was drafted, that our friends are correct and the drafter's intent did not intend to include Aboriginal peoples outside of Canada. However, the Constitution must be interpreted in a manner that renders it capable of growth and development over time to meet new social, political, and historical realities often unimagined by its framers, as stated in the 1984 Supreme Court of Canada case of Hunter and Southam. Now, while Hunter and Southam was about the interpretation of Section 8, not Section 35, the application of this principle in the context of Aboriginal rights has been recognized by this court in the 1996 Supreme Court of Canada case of the Crown and Vanderpeet at paragraph 21. And it's this principle which is the very reason for why a court must undertake a purposive approach to Section 35. Another concern that was raised by our friends is that by interpreting Section 35 out of the linguistic or historic context, that we would be overshooting the original purposes of the provision. However, the court is allowed to read Section 35 in such a way to meet the current situation, as long as it is still in line and set within those original purposes of Section 35. Now, the two purposes of Section 35 were first iterated in the case of Vanderpeet and reaffirmed again in the 2001 Supreme Court of Canada case of Mitchell and MNR. And the purposes of Section 35 are to recognize the fact that the land was already occupied prior to European arrival, and to reconcile that fact with the assertion of Crown sovereignty over Canadian territory. Section 35 acts as a constitutional framework through which these purposes can be accomplished, and the acknowledgement that distinctive Aboriginal societies occupied Canada prior to the arrival of Europeans in the case at bar the Sinext is fundamental to interpreting Aboriginal peoples of Canada under Section 35.
So, Counsel, in your position, does sovereignty extend over to these groups like the Sinext and to those groups that have claims to Canada before Constitution was enacted?
Yes, we submit that they are part of that shared sovereignty that our friend submitted. And I'd actually like to direct the court's attention to the idea of shared sovereignty, which was drawn up in the case of Mitchell. And in those same paragraphs where that idea of merged or shared sovereignty is iterated, it states in paragraph 129 that it is this entity as inheritor of historical attributes of sovereignty with which existing Aboriginal and treaty rights must be reconciled.
Counsel, sorry, but at paragraph 132 of Mitchell and MNR, at the last sentence, the court says that Aboriginal rights are exercised as rights in the 21st century by modern Canadians who wish to preserve and protect their Aboriginal identity. That's just one example out of numerous case law that specifies that Section 35 is for Aboriginal Canadians, not for those outside of Canada. So how do you reconcile all this case law with your proposed definition of Aboriginal peoples of Canada?
We submit that Mr. Desautel and the Lakes tribes are Aboriginal people of Canada because of their ancestral tie to that land and through their connection to the Sinext. In paragraphs 17 and 23 of the trial decision of this case, it states that the Sinext are referred to in the historical literature interchangeably as a Sinext or the Lakes or the Arrow Lakes people, and that each of the names by which the Sinext either identified themselves or were identified by others serves as evidence of a clear and ancient link between the Sinext and the Arrow Lakes region. And so we submit that through that historic tie to the Sinext, who were up until their extinction that was recognized in 1956, undoubtedly a people of Canada, that the Lakes tribes through that connection are a people of Canada.
The Council, we're talking about the modern exercise of Section 35 rights. And as I just stated, Mitchell says that Section 35 rights are for modern Canadians. How do you reconcile that?
The idea that was drawn up in Mitchell is a reflection of, in that case was Justice Binney elaborating on Mr. Mitchell's proposed framework that both Aboriginal people and Canadians have a shared sovereignty. And I'd like to draw attention to, in the facts of that case, Mr. Mitchell attached his Aboriginal right under Section 35 not as a Canadian citizen, but as a Haudenosaunee citizen. He attached that right to his Indigenous identity, not to his identity as a participant, as a member of Canadian society. And so that reasoning of merger shared sovereignty was not meant to be taken in such a way to exclude groups that straddle the international border or may exist outside of Canada.
Well, how do you explain Beckman, where Beckman and Little Salmon, where Justice Binney says in paragraph 10 that reconciliation, that section 35 is for the reconciliation of Aboriginal and non-Aboriginal Canadians, or Vanderpeet in paragraph 19, where the court says that Aboriginal charter rights are only held by Aboriginal members of Canadian society. There's more case law apart from Mitchell that make this sort of statement.
I see that my time has nearly elapsed. If I may address those concerns and then briefly conclude. First, with regards to the case of Beckman. Now, in Beckman, that case was about the interpretation of modern treaties, not about Aboriginal rights. But what treaty rights and Aboriginal rights have in common is that they engage the honor of the Crown, and the honor of the Crown cannot overlook the historical attributes of that assertion of Crown sovereignty.
Sorry, Counsel, one more question about that.
I'm sorry, Your Honor, that is time. Unfortunately,
Okay.
we'll have to move on. Thank you.
Second respondent, whenever you're ready.
Good morning, honorable justices of this court. My name is Avery McKinley, and I will be concluding the final submission on behalf of the respondent, Mr. Richard Lee Desautel. Our final submission is that the requirement for continuity was met in the lower court's application of the Vanderpeet test. In regards to this test and the application, the role of this court is to rely on the findings of fact made by the trial judge, as it is a fact-specific exercise, and to assess whether those findings of fact were both reasonable and support the claim that an activity is an aspect of a practice, custom, or tradition that is integral to the distinctive culture of the Aboriginal community or group in question. The issue regarding the Vanderpeet test in this case is not the temporal gap in continuity, as stated at paragraph 130 in the case at bar, and further expressed in the 1996 Supreme Court of Canada case of the Crown and Vanderpeet, which states that an unbroken chain of continuity is not required. The dissent takes issue with the evidence raised in support of continuity for two reasons. One, because of the seasonal round of hunting in Washington being site-specific, and because that they find that the connection existing in the minds of the Lakes tribe as insufficient. We submit that the temporal gap from 1930 to 2010 cannot be used to preclude an Aboriginal right to hunt, and that the evidence presented is sufficient to establish continuity. The sites.
Can I ask you, I'd like you to address the floodgate argument that was raised by the appellant, such that if we extend the rights of Aboriginals beyond those who are Canadian citizens, we actually risk and potentially threaten the livelihood and the access to Canadian Aboriginals who are otherwise protected under the Constitution.
Yes, Justice. This concern is addressed at paragraph 76 in the case at bar, which states that because groups outside of Canada are not implicated to this process to the same degree, the scope of the Crown's duty to consult with them and the manner in which it's given effect may differ. Our friends cited the case of Haudenosaunee Nation, which is, the issue mainly is that the government must consult if an Aboriginal right is at stake. But what we are here today to decide is whether or not the Aboriginal right exists.
No, I'm talking more about the argument raised by your friend, giving the example of lobsters off the coast of Newfoundland, of which there is a shortage, and extending the right to hunt to non-Canadian Aboriginals thereby decreases the supply that's available to Aboriginal Canadians. So we can certainly take that same argument and apply it to the West. such that allowing non-Canadian Aboriginals to hunt in the West will decrease the available, animals that could be hunted for by Canadians. So I'd like you to address that concern raised by your friends.
Yes, Justice. This issue of conservation should be determined where it is the central issue in the case, with full submissions and thorough consideration at the trial and the appellant level, as stated in paragraph 79 in the case at bar.
No, but I'm asking you for our consideration. What if us as the judges actually accept that there's the possibility of a shortage for Canadian Aboriginals? How would you address that argument?
The existence of the right is specific to each Aboriginal community, Justice. And that's expressed in the case of Gladstone. So ultimately, because this is just concerning the Lakes tribe and their involvement should they exercise their hunting practice in Canada, this would only really implicate that group. That issue of how this would implicate other groups should be resolved in a later day where there can be full submissions made on this manner.
You don't think it's a policy concern?
It could be at a future date, Justice, but in this case, we are only looking to see if the right exists at all. Additionally, in regards to the scope of Aboriginal rights, the site-specific requirement, which was first set out in the 1996 Supreme Court of Canada decision of the Crown and Adams, intended to widen and not narrow the scope of Section 35 rights. In regards to the concern about the right being site-specific, if we follow the reasoning in Vanderpeet, which states that the court must not focus entirely on the relationship of Aboriginal peoples to their land, to the point that they lose sight of other factors relevant to the identification and definition of Aboriginal rights, the court must also consider the relevant context, including the Aboriginal perspective. And to avoid unnecessarily narrowing the scope, the Aboriginal perspective and the underlying purposes of Section 35 are integral to this understanding. The Aboriginal perspective in this case includes the evidence that the connection to the land was still present in the minds of the members of the Lakes tribe as found at trial. Vanderpeet states that the significance of the practice, custom, or tradition will inform a court as to whether or not that practice, custom, or tradition can be said to be truly integral to the distinctive culture in question. Therefore, the fact that this practice never left the minds of the Lakes tribe demonstrates its very significance.
Counsel, I want to talk a little bit about abandonment here, right? Because your friends on opposing side have talked about the fact that, the land's been abandoned for some 70, 80 odd years, right? Certainly there may be a constellation of factors, and we hear that in the lower court's decision. Is there ever a point in which abandonment comes into play? And if so, what does that look like? Like, what's the extent to which somebody, an Aboriginal group, has to have abandoned a territory for them to then lose their Section 35 right?
That would be if the move was perhaps completely voluntary. And I'd also like to point out that the Lakes tribe never actually left their traditional land. They're still within that entire geographical area. They were just merely moved down south. I'd like to just delve in a little bit to the reasons for this gap in time, as you mentioned, was a constellation of factors. This includes the effects of European arrival and influence, which includes the 1846 Oregon Boundary Treaty and acts making the hunting practice illegal, such as the Game Protection Amendment Act of 1896 and the Wildlife Act of 1996, and also the impacts of residential schools. It states at paragraph 73 of Vanderpeet that European arrival and influence cannot be used to deprive an Aboriginal group of a valid claim to an Aboriginal right.
And counsel, that's my exact question. Can there ever be actual abandonment? Because I think the constellation of factors that you've just raised there affect, although not the same, they affect all Aboriginal groups to some extent. So I'm wondering if there's ever going to be an abandonment argument in play here, or are, any Aboriginal groups in effect that have any connection to Canada are they all going to have the 35 right moving forward?
No, Justice, because the extinguishment of an Aboriginal right cannot happen if the right is elevated from into Section 35. And also it is possible for an abandonment of this right as you described, but when we look at the evidence presented in this case in establishing continuity, the fact that the seasonal round of hunting continued in Washington despite the displacement of Aboriginal peoples, and also the fact that it maintained integral in the minds of the Lakes tribe, shows that we cannot simply extinguish or abandon these rights. The case of Mitchell also reiterates that rules of evidence are not cast in stone, nor do they exist in a vacuum. So these rules of evidence should be interpreted flexibly. Vanderpeet also emphasizes the promise of Section 35, which recognizes that the protection of the Aboriginal rights reflects an important underlying constitutional value, which states that the Constitution is rendered capable of growth and expansion. If I may have an indulgence to conclude.
I'm actually going to throw one more question here and then you can conclude. The question is, because your friends on opposing counsel raised, common law, Aboriginal rights, land titles is another thing we hear about in this case. Why aren't we using those as solutions? Why is it the Constitution, and why are we asking the Constitution to grow as the answer here instead of those other options?
Because the rights are elevated into constitutional status at Section 35, and also those were not the claims brought forth by Mr. Desautel. The submissions made by our friends would be essentially using this court, with all due respect, as an instrument of the law to cut an ancestral connection that, despite all odds, survived colonization. We respectfully request the Supreme Court of Lions Cup to not only dismiss the appeal and uphold the lower court's decision, but to step towards reconciliation, decolonization, and healing. Barring any further questions, this concludes the submissions on behalf of the respondent.
Thank you, counsel.
Thank you, justices.
Thank you for your thoughtful submissions, Mooters. Judges, thank you for your diligence and attentiveness. At this time, Mooters, please be careful when you select leave room. Please leave the breakout room, not the meeting entirely. I want to remind everyone that there will be no feedback, and so there will be no returning to this courtroom in general. Congratulations. Let's leave the judges to deliberate.
And I'll just also ask the honorable justices that once they have selected a winner, to please text Jen Lauristani with the winning team number and competitor names. And for the justices' convenience, I've posted in the chat a list of all the competitor names and Jen's phone number.
Thank you.
Chief Justice has to do that, right?
Yes,
So
that's correct.
That falls on me. This is the homework. Okay.